So Kevin and I are going to literally race through this because we got a ton of content, and we would actually love to have some discussion because some of the content's controversial. We'll just admit that right up front. So if we see some smoke coming out of ears, we know we've accomplished our mission. But I'm going to go first. We did this, well, some of you may know that these famous COSCA guidelines for public access were done in 2002 by basically Alan Carlson and Martha Steketee. And they have been used as the benchmark for public access policy for ever since then, 15 years ago. But if you think back, those of you who were in the courts in 2002, if you think back then, there were very few courts at that point that had implemented e-filing comprehensively and had electronic courts. There were very few courts that had put a lot of their data or documents out to websites. So basically, they were making policy mostly in a vacuum and trying to guess what the best practices should be. So since then, we've learned a lot. And what typically happened is as states did, get some echo here, as states did e-filing projects and as they started to put their information out on the web, we always advised them to do their access policies first, and they always ignored that advice and did it afterwards when the demand grew. But as they did it, about half the states did, they followed the model policies, the guidelines, just roughly about half. I mean, literally followed them to the extent that the structures and sections and clauses and sometimes even the verbatim language was the same. So those model policies were really influential. However, the meat of those policies, as we all know, is what's open to the public and what isn't. And because there was absolutely no consensus on that in 2002, they basically punted on that. They've got a section in the policy where they talk about the criteria that you should consider when you make that decision, but they made no recommendations in that model policy about what should be opened or closed. And one of my punchlines, which I'll freely give to you ahead of time so you can go see another session, is that, as I'll show in a few minutes, even now there's not much consensus about what should be opened and closed across states. So that situation has not materially changed in the 15 years. So what brought this about was that we knew that we'd had all this experience, we wanted to update the model policy. We held a couple of focus groups toward that end last year. And at the same time, the Center for Court Excellence, which is a research arm associated with the DC courts, had separately gotten a grant to do some work in this area, and we teamed up with them on a survey last year that we got a grand total of 21 states to answer, and some of the data I'll show you is based on that survey to try and find out where courts were at now as we went about revising the policy. Oh, come on, there we go. All right, so I'm just going to show you a few kind of typical examples of the data that came out of that survey. So remember, this is out of a sample of 21, not 50. How many states are opening these kinds of information? You can see almost everyone's opening dockets, and then it starts to rapidly dwindle until you get toward the bottom and it's under half. So not all over the place, but still significant lack of consensus. Even more so here, almost everyone's got civil open. A lot of people, 3/4 of them have criminal, and then it rapidly dwindles. But then, I changed the slide already, but one of the things that you noticed on that slide was some things at the opposite extreme, some things that everyone, quote unquote, knows should not be open. There's always a couple of states that open that kind of information, right? Like child abuse, which you would think everyone would close. Almost anything you can find somebody that's opened or closed it still. So now we're looking at information, and you see the title, not always. You would think that you would always protect things like child abuse and victims and so forth. Not always, but most of the time. This is a different issue. So this is the question of if you're providing public access information, do people have to register or not to get that information? Because by definition, what it means if it's public access is it should be anonymous, right? So do states require a registration or not? And as you can see, a sizable subset, somewhere around 40% of our sample, do require registration, and another big chunk sometimes does and sometimes doesn't. So courts are all over the place on this. This is my theme. The fees, a little more lopsided. You can see there about 75% are not charging fees, but here's the caveat on that. The tendencies are, if people are accessing court data, then the courts most often give it for free. If people are accessing case documents, people most often charge a fee. It's just that a lot of places haven't gotten to court documents yet. But the ones that do are mostly following some version of the federal example with PACER, where they're actually charging for the documents. And I think that's partly, as we all know, because clerks have had historically a revenue stream over providing physical copies of documents, and they want to protect that. And then what kinds of actual data elements or information are typically protected? Well, none of us are surprised that Social Security numbers and financial data are in there, but remember, those 16s and 15s mean that there's 6 and 5 states out of our sample that don't protect those, which is mind-boggling. You wouldn't think that would be anybody. And then so on down. Then at the bottom, those frequencies are even lower. Things like employee ID numbers, medical records, driver's licenses, things that some of you might think would always be protected are often not protected. Okay, so this is our other major theme, and Kevin's going to talk about it more than I will. But as we went about revising the model policy, one of the things that we realized two things. One is that the redaction strategies that courts were using to protect personal information and confidential information were not very good. So I'm going to spend a little bit of time here talking about how failed the strategies are that the courts have been using. Not because we're dumb, but because we haven't had good alternatives. And then I'm going to spend the second half of my little piece talking about how we think we have significantly improved alternatives now and what the impacts on policy will be because of that. That's kind of what Kevin and I really have as our punchline today. Now, I know, because I've been a technology guy part of my career too, that you always hear people say technology should not drive policy. And that's true. But what Kevin and I are going to try and convince you of today is that in this area we've had the opposite problem, where people have made policies without thinking enough about the practical issues of implementation, and that technology could really help now. So that's going to be our big punchline. But if you look up here, you can see the different strategies that people have used to try and redact the information that they don't want people to see. And you can see that while there's a mix, sometimes people are doing 2 or 3 different strategies in combination. There's a pretty high loading on the strategy of having the filer redact. So let's go through these options. One is to put the responsibility on the filer, and as you saw, that's the most popular alternative. Many states are using this strategy right now. So they tell the filers what they can't have in their filing and rely entirely on them to submit the information without that. How well do you think that works? Not very well. And then when you think about what percentage of self-represented litigants you have in your courts now filing for the first and maybe only time, you can imagine how much harder it'd be for that kind of strategy to succeed. We know that it doesn't work very well, but it's really popular with courts because it takes the liability off of them, takes all the expense of implementation off of them. So they pretend that it works. Second most popular strategy is what's been called in this area practical obscurity. So the idea here is there's some information in documents that is touchy, but you're okay with people who are worthy seeing it. It's just the unworthy people that shouldn't see it. I sound a little biased about this one? So let's say it's a divorce case, and Both sides have these awful things that they've said in their filings about each other. So they might have a state rule that says you can't put those online where the neighbor can see what's going on, but you can come down to the court and see it there. So they think by making it difficult, by forcing people to come down to the court can kind of have its cake and eat it too, because they can say that the documents are open, it's just inconvenient. That's practical obscurity. I might add that while the courts really like that strategy, there's no other type of government agency that does that. And then we have automated redaction, and the problem with this has been that it has been too bad at actually doing the redaction, too limited in scope and too expensive. So it couldn't meet the requirements. So here are a couple of additional strategies that aren't as widely used. One would be manual redaction, where a human being reviews every single document before it's posted. As you can imagine, that would be incredibly expensive. There are very few places that do that. A slightly less expensive version of that is, instead of doing every document that way as it comes in the door, and there are some states where people do that, they do it with the clerk's office coming in the door, and it's really expensive. They do it only if someone requests it. So there's a lag between when someone requests an online access to a document, and they do the manual review only of those documents right then. Still pretty expensive. The last one, which has been used with some limited success, is this idea of the confidential cover sheet. You see it most often in civil cases, but also in some family cases, where you try and segregate all that sensitive information to a separate form or document that then is confidentially filed. That actually is a strategy that has had some pretty good success when it's been used, but it hasn't been as widely used as we thought it would be. So after we've done all this, what we still need is that magic bullet that automatically redacts with a high reliability and a low cost. That's what would make us all happy. So if someone here is from Florida, I'm really not trying to give Florida a bad time, but everyone remembers that Manatee Pilot from many years ago, where they had a vendor who did a pretty good job of automated redaction on pretty simple targets like Social Security numbers, but they cost a fortune. So a lot of people remember that famous pilot, high cost, low capability, and said, automated redaction, not for us. And we've kind of suffered from that, but what people don't realize is that that was a number of years ago, and the technology has moved on. And in fact, those of you who have been following AI over the last few years and the kind of the deep learning and machine learning stuff, all that's been picked up by the automated redaction vendors over the last couple of years, and it's creating the same kind of capability revolution here that it has in other industries. So now what the vendors tell us is that that old example that scared everyone off from automated redaction was a generation 0 technology. It was a first generation technology, and that they've gone through 4 generations of technology capability since then. And so we should look at the newest things and see what they're capable of doing. And of course, Kevin and I are going, great, sell us that land in Florida. And one of the things that they claim, and this is something that we'd love to see, is that their automated algorithms would work well, not just with simple, well-formatted things like Social Security numbers, where you know what the format is, but also with unstructured information. That's the jargon for technologists. So it's something that could take multiple forms and could be anywhere in the document. You want to be able to find that in the unstructured document, the unstructured target. That's really difficult to do with an automated algorithm, but these new versions are starting to be able to do that. So what revisions did we make? Knowing all this, we've done our homework now, we know what the state of the art is, lack of consensus, somebody's doing everything somewhere, and redaction's gotten better, but we don't know how much. So that was the background for us revising the model policy. We found out that some sections we didn't need anymore. I got a couple of them listed there. Time's moved on, people have gotten more sophisticated. They don't need guidance on some things. There are some areas where there's still a lack of consensus, as I've said repeatedly now, the funding models, what exact case types and document types are open or closed. And in those areas, because the consensus was still lacking, what we decided to do in our new version of the model policy is to indicate the 2 or 3 most popular alternatives and the pros and cons on each, so that even though we couldn't say this is a best practice, we could say we've narrowed down the most popular choices to this small set and can give you some perspective on how to make the decision. That was the best we could do. And then the other thing that we did, which has made the policy people, as Kevin and I found out the hard way, I can't say it any other way, really angry, is to suggest that there's a tight relationship between the automated redaction capabilities and the decisions that you would make on a policy level about what's opened and closed. Because the truth is, what needs to be closed is almost never as coarsely grained as a case type or a document type. There's something inside a particular document, inside a particular case type, that's confidential or sensitive and needs to be protected. And so it's a question of how fine-grained can you protect that information. If the tools are good, you can open a lot of stuff. If the tools are bad, you have to close a lot of stuff. So the bluntest instrument is to close a whole case type just arbitrarily because your tools are so bad you can't afford, you can't dare to open anything because you might do harm. Then if the tools get a little better, you might be able to open a case type but close certain document types categorically. And if the tools get even better, you can open almost all the document types and just reach in with the tool and pull out the information that you want to protect. Does that make sense? So if you buy that kind of approach, you can see there's this really tight relationship then between your policy decisions about what's open and your tools and what they're capable of doing. And since in almost every state, if you go and read these policies, what they say is, by policy, the courts want to be open and transparent, and they only want to close things when there's demonstrable harm that can be done to people by opening them. That means that as their tools get better, they logically should open up more things. Okay? Are you with me so far on this one? So that's why we're super interested in how good the tools are. And we really stressed in our project report, writing about the revised policy, the extent to which those decisions should be made with those tool capabilities in mind. And one last point before we dive into this a little deeper, think about how those policies get made. If any of you have been involved in those public access policy cycles, typically what happens is they form a committee or a commission or something that spends somewhere between 3 months and 3 years trying to, literally, I mean, that's not even a joke, trying to figure out what that is. And then once they produce a report, then it goes into the front end of the Supreme Court rule cycle, which in every state that I know of is usually an annual cycle, unless it's controversial and then it's infinite. And so think about that now. We're talking about a rules revision cycle that takes somewhere between 2 and 5 years from a practical basis. And yet we know now these automated redaction capabilities at this point in time are getting significantly better every 6 months or so. And so you could imagine every year or two, maybe a year is too soon, but every couple of years at this point, wanting to be able to revise those policies in some flexible way. But right now, the court processes for doing that are so slow and heavy lift that that would be impractical.
Okay. All right, so what I'm going to do is give you a little bit of my experience and lessons that I'm still learning as it relates to applying the policy to our state, the state of Idaho. And I want to give you a little bit of context before I start sharing some of those lessons with you. Idaho is a state in transition to the digital court record. And you can see we're in the process of transitioning our courts over to the Tyler Technologies Odyssey platform and suite. And we have about 35% of our caseload has made that transition. The remainder of the counties will make the transition in the next 18 months. And as we've gone through this, as we've started this project, our policymakers have realized that we really need to do things differently as it relates to public access. And we knew that going into the project, but you don't really know it until you do it, and you're like, oh, how do we make this accessible to individuals, not just on the internet, but also when they come into the courthouse in a digital form. Give you a little bit more context. Historically, our redaction policy has been that whole filer approach, that it was the filer's responsibility. Our court didn't want to take on any of the liability associated with the access. And I'll talk a little bit more here in a second in regards to how we made this transition and this shift. Our new position, though, is really a shared responsibility between the filer as well as the courts. So that the filer still does have a responsibility to be able to identify or redact that information upon their submission. However, as Tom pointed out, it's very unreliable. And so we now have taken on some of the responsibility as well in regards to redacting this information. Unfortunately, I'm in the same camp as Tom. I hate practical obscurity. Not coming from the courts, it just seemed really ironic to me that I can come down and I can get the document at the courthouse, but I can't get it online. And then as we started to make this transition to digital court records, I'm like, great, let's put them online. And they're like, whoa, 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 slow your roll. And I'm like, what? It's public. You said it was public, right? If I can come get it, why can't I put it out there? And obviously, there's reasons why we don't do that. And to Tom's point, that's why we in Idaho, as well as other jurisdictions, are really, really interested in this technology, because it does help us really solve a real business issue within our courts. You can see we've been working on a proof of concept. In fact, Henry's here. He's going to keep me honest from Computer Systems Innovations, CSI. We've been piloting their IntelliDect product. There are other vendors in this space, so I'm not here to just push CSI by any means. The reason why we looked at that product in particular, for our case, is they are the preferred vendor and partner with Tyler Technologies and already have an integration built into their solution. So we're really looking for ease of use, proven technology, and the ability to move quickly. So the challenges to our implementation really started at that policy level. This is not our responsibility. We had some extremely robust conversations with justices, judges, clerks, elected officials, et cetera, around the shifting from the filer responsibility to us having any kind of responsibility. And I think that the real key moment that I remember in this conversation is when we had a judge stand up and say, you know what, we really probably don't have a legal responsibility to do this, but I believe we have a moral responsibility to protect this information. And we, as a court, really believe that we need to make this information and the documents much more accessible to the public. But in order for us to do that, we have to live up to our responsibility in protecting that data. And so that was really kind of the tipping point for us to really start to pick up some speed as it relates to our implementation. The other challenges in any of these projects is around funding. So if you're in a jurisdiction where you don't think it's your responsibility, it's kind of hard to get money for something that you don't think you should be doing to start with. But then you just have competing priorities. So like for us, we're in the midst of a major case management modernization. Finding that funding for us to be able to move forward is somewhat challenging. However, to Tom's point around the Manatee example, the cost of this technology has really started to come down. It is affordable, and as I'll show here, I believe it's also highly effective. Tom mentioned this as well in regards to the stakeholder buy-in, and really getting those stakeholders to the table early, particularly the rules committees, and making sure that they are buying into the process, that you're sharing with them, that in our case, that we're sharing with them the success of the technology, so that they can make more informed decisions as it relates to their policies and their rules. The other challenge that I believe that this technology has is just making it an organizational priority. In a lot of cases, people understand that it's important, but it's not urgent. I can still have somebody come to the courthouse and get a document. However, if you stop and you listen to the constituents, to the people that we're serving, in the public especially, they really do want this capability. And so making it a priority has been somewhat of a challenge. In fact, in my own case, I was just asked 3 weeks ago to deprioritize this particular initiative. And we've appropriately deprioritized it temporarily. However, we firmly believe that it's essential for us to be able to move forward to meet our overall goals. The last one is really around clearly defined requirements. And being new to the courts, this is probably the biggest challenge as a technologist that I've wrestled with. Oftentimes, I feel like when I read court rules, I walk away with that picture in my mind. We have a lot of if-then statements, nested loops, little one-off scenarios, etc. And as a technologist, it has been and is, even with this technology, challenging to meet all those collective requirements. And so I really believe that this has to be a dialogue between the technologists and the policymakers in order to really come up with a solution that works and works well in order to meet the goals of the judiciary. And so my recommendations here is really drive for that stakeholder agreement and drive for it early. You have to have a strong governance process. I'm really fortunate because I work in a centralized state and there's a pretty defined governance structure within our state. However, in talking to some of my colleagues who are either in a large county or they're in a decentralized state, you get those competing stakeholders who have equal authority, and you really have to decide how you're going to tackle this particular issue up front and get that governance structure in place so you can get to that agreement. The other thing is really push for those clearly defined rules and making it simple. What I say here is don't solve world hunger, or as I like to call it, don't boil the ocean. I find this all the time in the courts, and I think it's awesome because we want to do things right as a court system. However, we want to do things right to the 100th degree about that one-off case, or remember that case that we had in 1972 with the Boy Scouts, etc. And I really believe that if you can start to look at the minimum essentials, what are those things that we must do right now? And let's look at the 80%, and then over time, let's iterate and let's dial it in. And I think if you can get that dialogue going with your policymakers and your technology partners, you can make quite a bit more speed and solve this problem. So a couple of considerations I would encourage you to think about if you decide to go down this path, or if you're already in the transition, is one is testing. Testing takes a lot of time. It's a two-way street. And the reason why testing is so important is this is not a technology that you can just install, hit run, set up, and boom, you're going. You have to have the resources and the time to put into it. And the reason for that is you're teaching the system. And as Tom mentioned, in CSI's case, they're actually now starting to roll into a 5th generation technology with machine learning and artificial intelligence. The more that you can teach the system, the more accurate and more effective it becomes. And you're really looking for that ability to find that sweet spot, because you don't want to under-redact, but you also don't want to over-redact. And that testing is really essential to getting to that sweet spot. The other thing I would just recommend is making sure, and this is really again talking to some of my fellow colleagues, is making sure that you look at upfront the integration capabilities between the redaction technology and in particular your case management or your document management system providers. Again, that's one of the reasons why we are looking at CSI in particular, because that integration is already built and proven. In my understanding and research, a lot of those national case management, document management vendors, have a lot of integration capabilities built into their products. When you start getting to these regional-based systems, or if you have your own in-house system, really understand what the integration effort is going to be, because that is a major component of this initiative and of this project. So I'll give you some examples in regards to our experience. And our experience is still ongoing. We have primarily focused on structured data, really looking at personal identifiable information, PII, as you can see listed here, social security numbers, dates of births, etc. What we're finding, and the only reason I rounded down to 98 is I just didn't feel good about putting 99 there. No fault to CSI at all. But in my own personal testing that I've done in partnership with our team, I actually haven't found anything that it has not identified when it comes to structured data. It's highly, highly effective. The thing that I really like about this solution is it categorizes the findings into really kind of 4 categories, and it really makes it simple. It's red, yellow, green, and gray. So if it's green, it means that, hey, we have high certainty that you probably don't even need to review this and just send it on its merry way. We've redacted it and you're good to go. And what I'm finding is then when it does find that, it is very, very accurate. Yellow typically means, hey, we found something, but we think you should take a look at this. And really just more of that fail-safe capability. Red means, hey, I got a document in, let's say it's a, I'll use an example in our state with driver's license numbers on a citation. It's a citation document, but for some reason we didn't see a driver's license number. You guys should take a look at this before you do anything with it. And then gray is it's just benign. So what we're really driving for is try to automate as much of this as possible. Get the results really into those categories of that gray and that green so that the process just happens. There's very little manual intervention within that review process. The unstructured data is more challenging, and this is probably much higher percent than, at least in talking to Vic from CSI. So Henry's going to keep me honest here. Vic told me that he really would say that their technology is about 60-65% in the unstructured space to be able to automatically redact. What we're finding in some of our early testing, and some of this information also I took from some testing from some counties in Florida who are looking at this technology for a different purpose, is that it can really identify things that are less structured, that have context to them. And as Tom mentioned, through machine learning, it becomes much more accurate within that structured space or that unstructured space. The bottom line is the technology works. So we believe that the capabilities of the technology have dramatically improved over the last several years. And in our testing, it's very, very true. So a couple of last thoughts here. Operational considerations that I would just encourage you to think about is how do you trust the technology and trust the testing? One of the things that we are wrestling with, and it goes to the policy, that policy technology balance, is what are we going to automate? So we're definitely moving down the path of redaction. Now the next question is, what do we have confidence in the technology and in our testing to be able to fully automate? Because the last thing we want to do is introduce inefficiency within the system, within our process, if we've got the capabilities within the technology to be able to drive it much more efficiently. And then again, also talking about what are we always going to require a review of. Tom mentioned this. There may be some case types or document types in particular that regardless of whether or not it lands in the green zone, we're going to have somebody put eyes on it just because it is so sensitive. And so those are some of the discussions that we're wrestling with right now. The other challenge that we have is determining who's going to do these reviews. Because as you can imagine, those of you who've gone through a case management system modernization effort, you're moving a lot of cheese, and it's a big change. It's a big change concern. The one thing that we're wrestling with is not adding another thing to our court clerks. Now we're a fairly small state from a volume, and so we're looking at a centralized approach, more of a hybrid approach, where we have a centralized staff that has the primary responsibility for doing these reviews, but then giving the local county clerks the ability to also do some reviews in order to speed up the process if needed. The last thing that we're also in discussions with CSI on is how to integrate this into the e-filing process. So when the document comes in, it goes right through the redaction process, because one of the things that I'm learning is that as we've moved to mandatory e-filing, our court clerks are really passionate about that review. Much more so, I think, no, I wouldn't say this in front of my court clerks, that I think that when they got that piece of paper and they just hit it with the chunk machine, they really go through the process and they want to make sure that you've met all the criteria and you haven't hit one of those 8 rejection reasons. By embedding that review process within the e-filing review, we think we can also speed up the delivery of the system in that aspect. Last couple of things that I want to talk about is really changing the value proposition. So one thing that I'm really, really excited about, and Henry actually gave me a walkthrough of some early prototypes when we were working on this project together for the policy paper, is moving away from looking at the technology as a redaction tool and looking at it as a data extraction tool, where redaction starts to become the side benefit. So what you see within the policy paper once it's published is that the National Center estimates that about 85% of the workflow of the work that our court clerks are doing can be automated. And through this data extraction technology, which is the same technology you use for redaction, you can really start to achieve that. I've given a couple examples here, and through the process of this virtual data entry, of being able to take the information off of a document, automatically populate it into your case management system, and then automatically create the case or whatever that action is, that's one less thing that our people then have to do. So my examples here is potentially eliminating data entry from non-interface systems. So in my state, we have several counties that have e-citations, but we have a lot of counties that don't. They still write paper cites. And I've been in a couple go-lives where I've manually been entering citations to help the court clerks get through the night. Not my most favorite thing to do, and I'm not the best data entry person, and so now I introduce a little bit of quality issues. By using this technology, I can process those documents through the system, take that data out of the citation, drop it right into the system, off I'm running. The other aspect is around that minimizing the e-filing review. So again, And this is kind of contrary to my idea of putting it in the chain there with the e-filing review, but if we can minimize the amount of time that our court clerks are having to do with that review so that the technology is looking at it and making the decision on the criteria of whether or not to accept or reject a filing, we believe that the technology can do that as well. So if you could just hit the link there. So there's no audio or associated with this, but I wanted you just to see, if you could hit play again and just let it run. So a few years ago, people started talking about safe self-driving cars, right? And I was like, yeah, right, whatever. I drive this old Geo that is my commuter car. I'm gonna run it into the ground. It's 300,000 miles. I'm really proud of it. I definitely don't have this kind of smart vehicle. But the point is, and Tom mentioned this, is the technology that companies are using, whether it's CSI or these other vendors, they're really fundamentally using the same technology that you see in this Tesla, or the same technology that was in my Uber the other day with around some of the sensory capabilities within vehicles, and the ability for the system to learn. So in this video, as you can see, you'll see data points popping up on the right-hand side. That's the system identifying things, but then also cataloging that and learning from its experience. That is really where we're at with this technology. By moving from that Generation 4 and now into the Generation 5 technology, we can teach the system to help us with data classification. We can teach it to do the other things that you see here, to do the automated redaction, to help us with that extraction, to navigate the application on its own, not having a human there. It just navigates right to the correct field and does that data entry for you. If you start to think about the benefits of how you could really solve some real business problems and drive some massive efficiency within your court system. And oh, by the way, now you've solved your privacy issues around redaction. The value proposition for this technology significantly changes. And so that's why we are extremely excited about this, not just because we're trying to solve privacy concerns, but we're also now looking at it to be able to improve our overall capabilities as a court system. If you could just advance to the next slide for me. So in conclusion, and we want to leave time for questions, we really believe through this policy discussion and through our pilots that we've been working on in Idaho as well in other states, is that there's opportunities to improve our court operations. And frankly, there's opportunities to make our court staff much more, the work that they do much more meaningful, to really change the value proposition of what they're contributing to the courts and letting technology take on some of that aspect. I can say this for sure, there are ever-rising expectations of the public. I hear about it all the time from my friends and constituents that we serve, particularly attorneys and the public, is they are expecting us as we make this transition to digital court records to make those digital court records available. Our court is expecting us, obviously, to be able to protect the information that people have either voluntarily or in a lot of cases involuntarily given to us. And we really believe that this approach, following this policy as well as using this technology, allows us to achieve both of those. And finally, the last thing I would just say is this is really not a technology issue. It really is around policy, procedures, and helping to drive to that value proposition. So we're really excited about where we're headed with the state, and we'd like to open it up for some questions.
Nope. Just 1 second before
sure.
you do that. Don't sit down, though.
Yes, sir.
So enough about us. Let's talk about you. There are two things that we're going to try and do in the next little while about this if you're interested. One is that the project that we've been talking about, we're producing a project report that includes all the information we've given you here, plus the revised model policy that we talked about at the beginning. That project report will probably be out within the next month. My best guess is in less than a month. And you'll be able to find it both on the National Center's website and on the State Justice Institute website, SJI, because they funded the project. And then the other thing is, if you're intrigued by the redaction capabilities, the National Center is starting to work on a kind of find out what they can really do experiment. And we've invited a number of vendors to set up their products with us, and we're getting samples of data, both structured and unstructured, from real courts like Kevin's, and we're going to test their products against those real data sets and see how well they actually work and produce data that would be useful for you to judge whether they're effective enough at the cost that they're offered to be worth looking at. So I can't give you an exact time frame on that, but we're pretty far down the road on that. So I'm hopeful that in the next 3 to 6 months we'll have public information that we could share with you on that would actually be practically useful for making decisions. And the one other point I wanted to touch on, build on, that Kevin made, was this idea that they may not be cost effective because the costs are still not cheap if you only use them for the privacy redaction purpose. But when he was talking about the automated capabilities for other processes, one of the things that I immediately thought of was, the Chief Justices in the Center over the last 3 years did this big national civil reform project. And one of the things that came out of that was some new best practices for doing case triage and case management. This would be a perfect application of that. We had some targets, some recommendations in that big project for automating case triage and case management up front and as the cases proceed. So that's a perfect example of applying what Kevin was talking about and getting more value out of the product for the same price.
Yeah, exactly.
So that's it. If we haven't put you entirely to sleep, we'd love to have comments and questions.
Ma'am?
So are you suggesting from, when we're talking about redacting, not just redacting social number, date of birth, that kind of thing, but from a privacy perspective about that divorce case, that you're still, it's available for public access online, but you've redacted something out of those documents within the document itself. How do you determine what you're going to redact?
Yeah, that's a good question. You want to take a shot?
And is there a policy? Because that's something we are all. Now I'm a clerk.
Yeah.
And we do grapple with the whole notion of it is public record, but it's very sensitive. It may be sensitive information. You don't want your church members and co-workers and neighbors to or children, for that matter, in some cases. How do you make the determination to I pulled together a focus group that included media, attorneys, and Joe Public, and depending on what your perspective was, media, of course, and most attorneys, everything should be out there. And so then we came down to, if you're a party of the case, then you have full access. But it's a tough decision. And so this is the first time I'm hearing about redacting sensitive information off a document, and I don't know how you make that determination.
Yeah, so there's a couple things we can say, but unfortunately there's no magic bullet to this. Yeah. You heard me talk at the beginning about people forming committees and commissions to decide what by policy should be opened or closed. And there's no way around that step. That's a messy process. And one reason that there's no consensus across the states on that is, as you can imagine, if you get together any group of 15 or 20 people, no matter how represented the stakeholders are, group dynamics takes over, personalities take over, people make decisions that are different in every state. And so that's part of why and there's no right answer, right? And the reason there's no right answer is because you're trading off benefits and harms to try and figure out what to have open and closed. The only way we've really helped you with that, we could help in two ways, but we can't get past making those hard decisions in that hard political process. One way we've tried to help is, if you went back and looked at the original model policy, it listed, I believe this count is right, 14 different objectives that the policies were trying to simultaneously optimize. Well, I can tell you that you can't simultaneously optimize 14 anythings, That's just not possible. And that doesn't even provide any help, because a shopping list like that doesn't help you focus down and make hard decisions. So one of the things that you'll see in the revised policy is that list now consists of 3 things, 2 things that are benefits and 1 thing that's a harm. And so by focusing really tightly on what really matters from an objective point of view for the court, we're trying to help people with clearer vision make those hard decisions, those trade-offs between what they can open and what they can't. So that's one piece. And then the other one, which I think we're excited about, is, and I know this is jargon, but try and hang in there with this. these products have always done that kind of simple structured stuff like Social Security numbers, but a lot of documents and a lot of case types are closed because some of the really sensitive information is unstructured. It doesn't come in a predictable format, and it really requires quite a sophisticated capability in order to reliably identify it. And so there are huge chunks of information in every state that's closed right now because of that. And when you hear Kevin say that in their pilot, they can reliably identify 86% of that kind of information, well, 86% is not 100, and if the harm's high enough, you still might close the stuff. On the other hand, it might start becoming reliable enough that you could do a machine pass and code stuff and then do a manual pass that you could afford and safely open more stuff than you can now. So they're just new possibilities, but they're still hard decisions. Yeah.
Tom, I was on that original national committee that came up with the 2002 guidelines, and I can tell you when we started, every person in the room started with the idea that, hey, if it's available at the courthouse, we're going to publish it. I can tell you by the time we had thought it through, every single person went the other way when you get into some of the details.
Yeah.
There is a huge difference between making stuff public versus publishing it to the entire planet. And there's a whole series of serious problems. Let me just give you two, and I'll have a question. Divorce cases. We cannot find any good public policy to put up routine divorce and all the scurrilous things that people say about not only each other, but about their children. You know, children have been molested, children, or third parties that may not be, well, they're not a party, people who are not part of the case, like my husband had an affair with Ann so-and-so. Well, she has no idea, and a way to defend herself may not even be true. That stuff is really difficult. So we're not putting that up. We just had actually our largest court in the state take down minute entries, really, because of all the things that crept in and people complained about. The federal courts just contacted us about people being killed because of public access to federal documents, with criminal sentencing documents, where it shows one of the mitigating factors is cooperative witnesses. Well, that shows up, gangs were using that to kill them and their families. So anyway, stuff's really tough. But here's the question for Kevin. We don't redact. We get, in our Maricopa court, we get 10,000 documents a day, thousands of requests. There's no way we could ever have humans look at all these things and redact. When you take on the duty, how did you get past, you also then take on the liability. So if there's a wrongful death or a suicide or some financial loss because you said you were going to redact, it didn't happen, how did you get past your lawyers and your risk management people?
Well, I'd say we're still working through that, quite frankly. Our justices in particular, though, really believe that what they're trying to do is to take on an approach where the filer still has the liability and that we are taking on some responsibility. Now, I'm a technologist, not an attorney. So I turn to them and go, okay, help me navigate those waters. But that has been the big rub.
Well, maybe, Tom, the policy committee could address that, because I think once you take on the duty, you're going to have liability hooked to it.
Yeah,
And
yeah.
you may not be 100% liable, but
Right.
that's been one of the stumbling blocks about clerks trying to take on that duty.
Yeah, well,
for sure.
a couple of reactions, Dave. One is that there are a number of states that have taken it on, and as far as we know, they haven't been successfully sued yet. So while the liability exists, it hasn't really cost them anything yet, but it could. But the other thing I wanted to react to is your comments about the divorces. We do not want to give people the impression that we're for opening everything.
Yeah.
And just because redaction's there, we do not agree with that. And in fact, I think the logic of our argument against practical obscurity is that if documents have information in them that's harmful enough, it shouldn't be open anywhere, not just online. It just should not be open, because, you know, a lot of times, even with practical obscurity, what they allow people to do is go to the courthouse physically and access the documents electronically on a public computer, which could be mined easily with technology and create the same kinds of harms as if it were online. So far from arguing that everything should be open, we would argue when the harm's great enough, they should be completely closed and not just partly closed.
The problem you have is many states, they don't have constitutional requirements to have open records, so that's why that...
Yeah, I understand. Yeah.
But to Tom's point, just from my experience as well, is what I would encourage you, and this goes back to my don't try to solve world hunger. Don't let divorces, juvenile, what have you, prevent you from doing what you can do. Because that's what happened in our state, is we went to practical obscurity for everything because we couldn't solve these use cases. And those use cases are difficult decisions that require a good, healthy dialogue, as well as I would say, if you decide to go forward with some of this, literally with any of it, is have those clearly defined rules. Because the other challenge that I find is that court clerks oftentimes take on that responsibility themselves based on their own preference. And so you really have to have clearly defined rules, not just for the technology, but the people that are managing these documents as well.
Yeah, hi, I'm from Florida, not from Manatee.
Oh, we're in trouble
I'm familiar
now.
with their experience, though. I worked in the clerk of court's office for many years. I'm now with the court administration. I also served on the Florida Bar Committee that worked on some of the rules that you're talking about. And we have a 3-year rules cycle, so it's like turning the Queen Mary to get the rules updated.
Yeah.
But in response to what you said, Florida's got, I think to say it's a hybrid approach would be understating. We have several different levels. One, we have a Supreme Court administrative order on what can be released online. You can release, as you said, many more things if you come down to the courthouse, but the Supreme Court has weighed in and developed what they call an access security matrix that says what you can release online and who you can release it to. So there's different types of viewers who have different types of access. Then the bar rules created a list of, I think we're up to 23 categories of documents that can be automatically redacted by the clerk without the court's involvement. If it is beyond those 23 document or case types or document types, then the court has to get involved and has to enter an order determining whether it can be redacted or not, or should be redacted or not. And the lawyer, the filer, is supposed to file a notice of confidential information in court filing. I'm sure you all know how effective that is. You talk about self-represented litigants not being compliant.
Right.
Lawyers are not a whole lot better, and I are one. So, so you have that.
Yeah.
But it's a constantly evolving process. This year, the legislature actually passed a limitation of liability to protect clerks who miss information that they're supposed to be redacting, but it's a dual responsibility with the filer and the clerk to identify those 23 categories of things. So I'll be interested to see whether that limitation of liability has any effect on the way
Yeah.
the clerks process
Yeah.
the information, because right now in our clerk's office, which uses IntelliDact, they have eyes on all the things that are red and yellow.
Yeah. So one reason I was brave enough to mention Manatee was because I got hired to do not one but 2 formal evaluations of the Manatee Pilot by the Florida court. So I understand everything you're saying. And the thing that I always find hilarious is that Florida has this reputation as being the most extremely open state, the Sunshine State, and yet they have the most complex public access rules of any state I've ever worked with. Yeah.
It's right. And the bar actually is struggling with that right now because of the fact that there is so little compliance, and they're convinced that it's largely because of an inability to understand what to do.
Yeah, so I mean, I think what Kevin and I would say, having spent part of our careers outside the courts, both of us, is that one thing that happens a lot of times in government is that when government agencies make policies, because they're not subject to competition, they ignore the costs of implementing their policies. So on the one hand, the more fine-grained and complicated you make the policies, the more costly they are to reliably implement. And so you see sometimes these policies, like Kevin was talking about, that are unnecessarily complex because it was a bunch of lawyers who sat in a room and made the policy up without any regard of the cost of implementation. So I think some sensitivity to those kinds of issues is warranted.
A lot of times the lawyers don't even have any idea what goes on after they file it that needs to be addressed.
Yeah, I mean, you're going to see the chip on my shoulder now, but some of you may know that the National Center, together with Courtroom 21, which is basically William and Mary Law School, did a court privacy conference for a number of years. We put on 10 or 11 of those. And honestly, almost every year I would go and there would be 100 lawyers and me, one technology guy. You know, and they'd be debating these really important issues in a complete vacuum as far as implementation went.
Yep.
I had a question concerning the redaction software that can work with searching emails as opposed to court documents. I recently had an experience where one of my judges had gotten into some legal issues with the federal government. So the media had really pounced on emails over a particular cycle. The IT department did some not redaction review, but tried to search on the search terms that the media had provided in their request, but it was so broad that it wound up with returning 6,000 emails.
Yeah.
Yeah.
Then after I found all kinds of errors, I said, look, you've got to put this back through the mill here. And then they reduced it down to 2,000. So then, I had myself and some select staff had to manually go through that whole process of going through the remaining emails. So is there something out there that can...
Yeah, so I've got 2 tips, and I think Kevin probably will have some too. My first tip is the brand new data center for the National Security Agency is 20 miles from my home. It's really big. It's this huge black building that uses as much energy as a town of 50,000 people. So what you need to do is take one of those employees and denounce them as a traitor to the NSA. They'll analyze all those emails for free.
That's right.
I'm just kidding. Or am I? The second thing I would suggest is you're really talking about the functionality that we usually think of as e-discovery. There's really sophisticated both software and companies that do exactly that kind of analysis, identification, removal, as part of e-discovery products. Not very widely used in the state courts because we don't get that many complex civil cases compared to the feds. Very sophisticated capabilities, so that's where I would point you.
Yeah, I would echo the same thing. That's in our last company. We use e-discovery tools to do that exact challenge that you're working through. As we wrap up here, I just wanted to highlight 2 things. One is we have top 10 tricks, say that 5 times fast, or 10 times fast, on the back table there, so please grab one on your way out. This is in partnership with the center as well as our Court Information Technology Officers Consortium, or CTOC. And so my shameless plug on CTOC is, if your IT officer is not part of the CTOC organization, we would really encourage him or her to connect with myself, and we have some other members here as well, because it's a great network for us to be able to exchange ideas, talk about different technologies to solve different business problems, that type of thing. The other thing that we're really trying to push for from a technology officer perspective is to do more partnership with people like you and the center on the business side. And really getting out of the data center and having this good, healthy dialogue. So if you're not part of CTOC, we'd really encourage you and your organization to consider it because we think it hopefully will bring some immense value to the court system over the next few years. I think we're out of time, so with that, we really appreciate your time.